Hello everyone, I am Darshana Baiju of BBA LLB. The topic for my presentation is trademark. I'll be explaining it by illustrating a case titled United Spirits Limited versus Silverhawk Distilleries Limited, which highlights some key aspects of trademark law in a real world context. Parties of the case: Plaintiff is United Spirits Limited and the defendant is Silverhawk Distilleries Limited. Now let's look into the jurisdiction. This suit is to be adjudicated before the High Court of Delhi, which has jurisdiction over intellectual property disputes in India. The case involves issues related to trademark infringement and passing off under the Trademarks Act 1999. Since the alleged violation of the plaintiff's trademark rights occurred within the territorial limits of Delhi, where the plaintiff conducts significant business operations and the defendant's products are also available in the Delhi market, the Delhi High Court has the appropriate jurisdiction to hear and decide the matter. Additionally, intellectual property matters involving registered trademarks fall under the jurisdiction of the High Court. The present suit was rightly brought before the High Court of Delhi. Now let's look into the facts of the case. The case involves two products owned by the plaintiff, namely Royal Fame and Classic Blue, both of which hold registered trademarks falling under classes 34 and 33 of the trademark classification categories. The plaintiff has a substantial history of using the term Royal Fame brand since 1995 and the Classic Blue brand has been in use since 1997. The defendant is accused of utilizing the disputed brand Regal Fame mark since August 2, 2017, which the plaintiff argues is confusingly like its own marks. Both the plaintiffs and defendants' products belong to the same market sector and namely Indian manufactured foreign liquor and are distributed in similar locations. The plaintiff, in response to the defendant's move to register the contested Regal Fame trademark under Class 33 and filed an opposition, further escalating the legal dispute. The issues raised before the court in this case are: first one is whether a case of passing off can be made against the defendant. The second issue is whether the defendant's impugned mark infringes the plaintiff's registered trademark. The arguments of the plaintiff are the following. Plaintiff held registered trademark for Royal Fame and Classic Blue in classes 34 and 33 respectively. The plaintiff emphasized its extensive history of using the Royal Fame brand since 1995 and the Classic Blue brand since 1997, highlighting the reputation and goodwill associated with these products. Both Royal Fame and Classic Blue were recognized as well-known trademark by the Delhi High Court and Madras High Court under Section 2 Clause 1 Clause ZG of the Trademarks Act 1999. As per the case Austin Nichols and Company versus Arvind Bell and Rhizome Distilleries versus Union of India, the plaintiff argued that these marks have become source identifiers closely associated with the plaintiff. Both the plaintiffs and defendants' products fall within the same market sector of Indian manufactured foreign liquor, implying that consumers might easily confuse the products. The defendant intentionally deviated from the mark it sought to register by using a blue background, mimicking to the plaintiff's packaging. The plaintiff opposed the defender's application to register Regal Fame trademark under Class 33, indicating a proactive effort to prevent the alleged infringement. The defendant's use of fame violated the plaintiff's brand reputation, emphasizing that fame is not a term descriptive of alcoholic beverages and therefore thus should not be used by others in the context. Arguments by the defendant. The defendant had legitimately and honestly created and adopted the Regal Fame mark on May 25th, 2016 and has been using it publicly since August 2017. The defendant's usage of the mark therefore predates the plaintiff's claim. The defendant relied on Section 17 of the Trademark Act to argue that the plaintiff cannot assert exclusivity regarding a part of its composite mark, Royal Fame. The plaintiff's attempt to register the mark Fame was unsuccessful. By filing the lawsuit, the plaintiff was indirectly seeking exclusivity over the term. The term Fame was commonly used by various manufacturers in the industry, suggesting that it lacks distinctiveness. The use of fame in regal fame does not constitute trademark infringement. Judgment. The court ruled that the plaintiff cannot assert exclusive rights to the fame component of the royal fame mark. Section 17 clause 2 clause B was found to be applicable to the fame portion of the mark due to its lack of distinctiveness as a generic, common, and laudatory term, affirming the plaintiff's right. The court held that the plaintiff can use the entire royal firm mark under Section 17 clause 1 of the Trademarks Act. While acknowledging the potential exemption of the dominant portion, the court applied the plain glance test and found no similarity between royal fame and regal fame marks. The court held that the defendant liable for passing off its product as that of the plaintiff. It invoked the presumption that the intention to deceive consumers about the association between regal fame and the plaintiff's brewery was successful, given the apparent deceptive intent. Analysis of the judgment. The High Court rejected the petitioner's claim of exclusive rights to the term pride within the blender's pride mark, correctly applying Section 17 of the Act and anti dissection rule. The judgment emphasized considering the mark, denying any monopoly over pride, while finding no prima facie case of infringement concerning the distinct imperial blue mark due to the absence of individually registered elements with secondary meaning. The court granted an injunctory injunction against the defendant's use of regal fame pending the suit based on the apparent intent to deceive consumers, supporting the claim of passing off. That's all about my presentation. Thank you for your attention.